Well, joining us to analyze the bill currently before the National Assembly seeking to increase the number of justices on the Supreme Court's bench from 21 to 30 is Professor Yemi George, a senior advocate of Nigeria. He is a professor of public law and president, Center for Socio-Legal Studies. Thank you so much for being on the news tonight.
Thank you.
I'm sure you're well aware of the arguments, both for and against it. The Senate is saying that, this will crush the backlog we are seeing with cases. But the NBA and other lawyers have reasoned in opposition, saying just increasing the numbers don't solve the issues on ground. In fact, some are proposing that strengthening lower courts and adopting advanced case management systems is the way to go. What do you say?
Thank you for identifying this issue, for bringing it to the front line, to the front line. Clearly, those who are proposing an expansion in the number of justices of the Supreme Court as a solution to the problem of delay are not aware of the real problems. It's not about number. It's not a game of number. It's not about packing more people to the Supreme Court. That's not what will solve the problem. The problem is making the system more efficient. And it's not necessarily about number. It is not, the moment you introduce number, you dilute the court. You reduce quality. There's a temptation that people who are less qualified will find their way into the court, and that endangers the justice system. That endangers the jurisprudence. So it's not about number. It's about what is the quality. What do we need to do? For example, the number of cases going to the Supreme Court. There are too many cases going to the Supreme Court. Cases about customary law from one village somewhere in the country goes to the Supreme Court. So we need to restructure the jurisdiction of the court so that only matters, just as the NBA has pointed out, only matters that are of national importance, matters that are of constitutional significance. Those are the matters that should go to the Supreme Court. So that when the court speaks, you know that authority has spoken. Another aspect of it is the issue of strengthening the appellate system. Many of these matters should end at the appellate system. The Supreme Court should be able to decide what matters we want to take. Like in some of the other jurisdictions, their discretionary power, their power to grant leave before some matters can come to the court. A situation where so many matters can go to the Supreme Court as of right does not augur well. That's why it's not the number. Even if you put 50 justices there, the backlog will remain. The backlog will remain. So we need to look at the kind of cases that go to the Supreme Court, and then strengthening the lower court, like the Court of Appeal, can take more cases. Yes.
Similar calls were made in the past to increase, from 15 or 16 to 21, and it was increased to 21, and still, apparently, the problems with the Supreme Court have not, really been addressed. But I would like you to point out, how to go about strengthening the Supreme Court, because you made a point earlier on the need to, make sure that the authority of the Supreme Court is firm and final. Would you say, from the things that have been going on in recent times, that the authority of the Supreme Court seemed to be waning somewhat? What do you think is responsible for that?
So thank you so much.
A situation where the Supreme Court rules, makes judgment, and still there are ambiguities.
Thank you. You have mentioned the word ambiguities. In recent time, there has been instances of conflicting judgments from the Supreme Court, especially on election matters. You find, different panels arriving at different decisions without commenting on the earlier precedents. That's very unfortunate. So that brings extreme uncertainty into the law. The law must be predictable. Lawyers must be able to advise their clients on the basis of established judicial precedents. In fact, our law is founded on judicial precedent. So there must be clarity of precedence. The situation where you set up so many panels, what will happen is that so many panels, will start to give conflicting decisions, which is the problem we have with the Court of Appeal. Now you want that to come to the Supreme Court on a higher scale. So that's why it is not advisable, it is not wise at all to think of adding more people to the Supreme Court, so to set up more panels. No. For the United States, for example, we can study an example. You know, the Supreme Court is similar to the Nigerian Supreme Court. They have only 9 justices.
Right.
9 justices. South African Supreme Court has about, I think, 11 justices. You know, dealing with only constitutional matters. You know, another country that has a very large Supreme Court is India, but these are about almost 2 billion people. Almost 2 billion people, you know, and that court has very wide spectrum of functions.
So how do you improve the justice delivery system at the Apex Court?
Yes, 3 things we need to do to improve and strengthen the justice delivery system. 1, we must ensure that only the best get there. And so far, the system has succeeded in ensuring that the best of our justices make it to the Supreme Court. The best of the best, the quality of appointment. Secondly, working condition must be provided. Excellent working condition. At the moment, you don't treat the justice of the Supreme Court well. The only member of the court that is well treated, adequately catered for, is the Chief Justice. Others are left, you know, on their own. You don't provide accommodation for justices. Some leave the Supreme Court and retire to some, you know, some places that are not appropriate for former justices of the Supreme Court. That's a shame. That's a shame. So we need to define the retirement package so that anybody who gets to that court, and how many of them, 21, is it impossible to make sure that we have decent retirement accommodation for all the justices of the Supreme Court, wherever they want to retire to, either in Abuja or Lagos or Yenagoa or Maiduguri, wherever they want to be. But you leave them on their own. You know, and then you make huge provision for the Chief Justice of Nigeria. You build him a house that is worth billions.
First among equals.
You know, and you make then of course the Chief Justice can still be first among equals. But we must not forget that the Chief Justice is primus inter pares. It's one among others. So the others too should be provided for. One tree does not constitute a forest.
Indeed.
Absolutely.
So you need all the justices of the Supreme Court to be confident that when I leave this court, I'm going to retire in comfort, so that the pressure on them will be minimal. The pressure will be minimal. So we've spoken about 2 things. Quality of appointment,
working conditions,
and then jurisdiction. See, what kind of cases should go to the court? All of this must be defined. And we have said only the matters that are of the highest constitutional significance. Those are the matters that should go to the Supreme Court.
Indeed. I mean, imagine you pointing out that customary cases are making it to the Supreme Court. It's appalling. But isn't it true that the entire judicial system is overburdened and outdated? Yes, this bill seeks to help the Apex Court. But does the problem not start from the bottom? And trickled up. So if we focus there, have we really solved the problem? You know, and then on the issue of consistency and predictability of outcomes, are there any concerns about that if we increase these numbers?
Thank you so much. You made a good point that we should not only take care of the Supreme Court. I agree with you absolutely. The entire justice system requires to be overhauled. You know, and this process I believe has begun. For example, for many years we are advocating for improved remuneration for judges and justices. That has been done. At least that's a good start, has begun under this administration, when the salaries and emoluments of judges were significantly enhanced. You know, however, it does not end with salaries alone. You see, you go to some courts now, you don't find places to sit, you don't find good seats. You don't have proper ventilation. You know, there are courts that look like a marketplace.
Libraries.
You know. So exactly. And then another area is the use of technology. The use of technology in our courts is very, very poor. It's very low. We use computers every day to manage our affairs. Why can we not use technology to improve our justice delivery system? Our judges continue to take down proceedings in longhand. And we have argued it again and again that the caseload of the courts will remain as huge as they are without any significant reduction, as long as our judges continue to write in longhand, an outdated mode of operation.
We'll have to leave it there. Professor Yemi Akinseye is a President Center for Socio-Legal Studies. Thank you so much for your brilliant insights tonight.